Hey everybody, thanks so much for joining me again today. I'm here with Travis Cook once again to talk a little bit about walkouts and employee demonstrations and how processors should handle them, respond to them, things like that. So Travis, thanks again for joining me. Let's start, from the top. What are the best practices for processors, for plant management, corporate leadership? How should they respond to a walkout or other employee demonstrations if they should happen to them?
Thanks, Andy. First, every facility should have a plan on how to deal with walkouts or strikes or any other what could be protected activity. And second, everyone needs to understand whether or not their facility is unionized or a non-union location. If it's a union facility, the first step, of course, is to look at the collective bargaining agreement, which I'll go into in a second. But if it's a non-union plant, you need to contact your lawyers because concerted activity is protected under federal law as it relates to working conditions. Generally under working conditions, which a work stoppage or a strike or a walkout would certainly qualify or likely qualify. If it is a union facility, the first step would be, again, to look at the collective bargaining agreement. From my experience, most collective bargaining agreements contain a non-strike provision prohibiting a walkout or a strike. I guess with that being said, the no strike provision in a collective bargaining agreement doesn't supersede the OSHA Act or Section 13A, which generally entitles all employees to refuse to work if they reasonably believe that there's an imminent danger. In this initial wave of lawsuits that we've seen several plaintiffs firms try to generate, a duty or at least bad press saying that these companies or the processors knew of this danger and they marched the employees right into it. Of course, none of those cases have played out, and we don't know the result, but that tactic has emerged. Each of these situations is different, and I sound like a broken record, but the collective bargaining agreement in one location or with one company in one local is different, or could be significantly different or importantly different from a different facility, and each agreement needs to be evaluated and as considered by counsel and the company and the management for that location and decide how to respond to a walkout or a strike. But my point again would be all those decisions should probably be prepared, and you should have a plan in place before you get to that circumstance.
So union or not, if the employees feel as though it's an unsafe situation, they're protected in some ways by the law or by the regulations. But what if it's not an organized walkout or official walkout or an official strike? What if it's just employees? There have been reports of plants where hundreds of employees simply stayed home in mass out of fear. Is there anything legal wise that can protect processors from the, damage to business, or is there any threat of lawsuits around those kinds of situations, or is it just, oh well, these people all called in sick and that's the way it's going to be?
Andy, we haven't seen any litigation to this point, or I'm not aware of any litigation regarding that. But again, it would be, you'd start with the collective bargaining agreement if it's a unionized employee, because that outlines the procedure for that shop and what you can do and how you can go about it. In a non-unionized facility, to reiterate the point, the law protects concerted activity. So that would be a case-specific, fact-specific investigation to decide whether or not this was concerted activity or individual activity. And you'd want to do that with your local lawyers. And then again, it's a fairly fact-specific investigation as to whether or not someone qualifies for the OSHA protection as well. But those would be the steps that you would take to start that analysis and try to get people back to work. And again, follow all the the CDC guidelines and the OSHA guidelines and communicate. And a lot of these union issues arise out of poor communication or, failing to have everyone on the same page.
Perfect transition to my next question. Based on what you've seen and heard so far, are processors now typically communicating better with their employees, getting them PPE, making sure that the employees know? Because, again, a lot of the initial big closures and walk-offs or demonstrations, whatever that we heard about in the media, you had the union employee side talking about how they really didn't know what was going on, and that's why they had to move forward. So based on what you've seen and heard, are you finding processors and plant management communicating generally better than they were maybe in the beginning, or with regard to the COVID-19 situation anyway?
From what I've heard, they are doing a better job or a nice job communicating with the employees. I mean, obviously, we've seen at least 2 lawsuits I can think of that would challenge that assumption. But my understanding is they've done a nice job galvanizing resources to get them to their facilities, and they've done a nice job working with the employees and with the unions in an attempt to keep the facilities open as somewhat ordered by the president, and keep the facilities running safely and all while maintaining employee safety. So those aren't the headlines we're seeing, but that's what I've been hearing.
So is communication really kind of the first step in defending yourself against this kind of a thing? Just communicating with the employees better, doing a better job of keeping them informed then?
Yeah, I think the communication is important, and it's one of the main tools in both having a successful relationship with a union in a unionized facility and preventing or deterring an organizing campaign in a non-covered entity.
Great. Travis, thanks so much. I appreciate the time. I appreciate the insights, and hope to speak to you soon, maybe in better times.
Thank you, Andy.